Hello, federal viewers. Today we are here talking about the haunting incident of the murder of Radhika Yadav, a state level tennis player who was shot dead by her father, Deepak Yadav, with a 0.32 bore revolver on Thursday at 10:30 a.m. in Gurugram. Radhika was shot thrice and she later succumbed to injuries. The police have arrested Deepak Yadav. Now, Radhika Yadav was shot dead at her own home in the in Delhi's upscale Sushant Lok area, and her father has confessed to the murder. He is currently in custody, and we have with us Delhi High Court Advocate Isha Bhalla to explore what the law has to say in this case and what lies ahead for Deepak Yadav. Thank you, Isha, for joining us today. Uh, Moving ahead, Isha, there are multiple speculations, and there are considerations of whether it could be an act of rage, or is it honor killing, or is it because the father was mentally unstable? What does it look like at the first instance?
Considering he shot his daughter thrice, there is no doubt that something did tick him off. And from whatever information that has been gathered till now, and what is prevalent, it shows that it was generally again a stigma in the society, and
Right.
maybe the neighborhood wasn't very friendly, or they were not very, I would say, educated in the sense that they're not comfortable with a female running her own academy.
Hmm. Right.
And there were other personal comments that were made.
Yeah.
That's what the father's statement is.
Mm-hmm.
But anything, this grave that you'll end up shooting your own daughter just because people
Hmm.
are provoking you, maybe, making any kind of slurs or statements, it doesn't
Right.
justify the act.
Right, right. It says that as per our sources we've confirmed that she was an employee, and the exact motive of the murder hasn't been found yet. But does this draw parallel? If you remember, the Arashi Talwar case or the Sheena Bora murder case, where the parents were accused for the murder. So
Yes, it is
how
quite similar.
hmm.
Yes, please complete your question.
Yeah, so I meant, like, in terms of, let's say, the proceedings, the sentencing, how would this be similar to that?
How?
How would the proceedings for this case be similar to what we have seen in the past in case of Arshi Talwar case and Sheena Bora murder case?
See, we cannot predict how this would go forward because in this case, the mother, it is as per again the articles that I've read, what the facts say that the mother was also present. The, at the time this incident occurred when the father shot his
Hmm.
daughter, the mother was also
Hmm.
there. But
Right.
she refuses to give any statement and she says she did not even hear the gunshots,
Right.
which is quite impossible. She said she had fever, she was in the other room. So her
Hmm.
statement does make a lot of difference. And
Right.
obviously, it can add weight to the evidence also during when the trial is being conducted. And
Hmm.
the mother's evidence plays a very pivotal role in all of this. However, she's refused to make any statements right now, but in future or maybe in the coming time when the investigation is completed, we
Right.
can
Right.
hope for something more constructive.
Right. Right.
So
Like
in
you're
these
right.
kind of situations,
Hmm.
I was saying the facts are very variable, and
Correct.
law stands with just what is available, the facts. That is what we
Hmm.
deal with.
Right, right, right. So, like, like you rightly said, that it was not that she was shot once, but thrice. In that case, that definitely points out that there was some sort of a trigger, and there was some sort of a incident that could have led to him taking such an extreme step. But at the same time, the mental health, or is there some sort of a mental illness that could have also been the reason behind this? So, is there any scope for insanity plea under Section 84 IPC for the accused?
See, in these cases, obviously, a lawyer defending a client like that would
Hmm.
definitely take that plea that he was
Hmm.
not in his, you know,
Hmm.
mind of
Completely.
prudence and he was of unsound mind. That is the
Hmm.
correct legal terminology that we use. But
Right, right,
again, you need to have, how do you justify it? You will
correct.
still, either there are two things: either you are legally of unsound mind,
Right.
which you call it insanity, or you
Hmm.
have a proper mental illness.
Right.
There are problems like you can be bipolar, or you might have some other disease or something. But
Right.
yes, so in
Hmm.
these cases, this is also a plausible area to discover, but this also can be done only during trial. They will have to prove. Just taking a plea of insanity itself is not enough. You have to
Hmm.
justify that. You have to prove. Again, you'll have to produce evidence. Either you
Right.
show your medical record that
Right. Right.
that person was already suffering or had some issue, or did not have the cognitive ability and could
Hmm.
not deduce the difference as to what is
Right.
right and distinguish it from wrong, what the act that he was doing. So
Correct.
again, to
Right.
draw all of that, it
Hmm.
is a matter of trial.
Hmm.
It
Hmm.
depends
Hmm.
like what strategy they take. And again, the mother's statement also comes in, and there have to be other evidences taken in, and they all have to
Hmm.
corroborate so as to prove
Right.
this. However, this is
Hmm.
again the other case that you referred. See, in
Hmm.
that case, there were multifarious people involved,
Hmm.
too many plots that could be discovered.
Right.
There were too many variabilities. But in this case, this man
Hmm.
has outrightly admitted that he shot his daughter. So this is a
Hmm.
outright clear case of admission. He's admitting
Hmm.
to murder, that yes, I did it.
Hmm.
Unlike the
Hmm.
other, wherein you have to get in the investigative team and go through
Yeah,
everything
there's
from A to
complete
Z and put
denial
all the
of.
pieces together.
Right. Right.
Correct.
Right. Mm-hmm. So, based on the available information, that we have so far, how was this particular case likely to be classified? Like, I mean, we know that murder under IPC section 302 would be applicable. What other sections would be applicable in this apart from this?
See, if it's not murder, the other option is, it's culpable homicide not amounting to murder. But that
Mm-hmm.
also, if he's able to prove his case, he's able to put up a good defense. And if he goes by the insanity plea and he takes that defense under section 22 of BNS today,
Right.
and he's able to
Mm-hmm.
prove that he was not in his right mind and could not distinguish and did not have the mental capacity to,
Mm-hmm.
but still,
Mm-hmm.
it could have been a possibility that this was also premeditated. We do not
Right.
know, because
Mm-hmm.
the brother wasn't there. The mother
Mm.
was also maybe there in the same room or in the other room. We do not know that yet.
Right.
And, he used his own licensed revolver.
Yeah, yeah.
So he knew he had it. It was in his own possession. And he waited. Maybe, the brother, had he been there, he would have been able to stop.
Yeah,
So
yeah, yeah.
all
Probably that.
things, and, he shot her while in the back while she was cooking. So all these
Mm-hmm.
things do add up, that, the man went for a stroll, came back, decided, my son isn't
Mm-hmm.
there, and my wife is not going to go against me. Picked up his
Right,
own gun and
right,
shot her. So
right,
again,
right.
there are so many angles in this, and
Mm-hmm.
as and when the investigation carries on, we'll be able to figure out as to what exactly happened.
Right.
There is another possibility, what if it's not just, her running an academy? What if there is another angle involved? Maybe, there is this one statement I read that she was
Yeah.
very tech savvy and she used to make a lot of reels. That
Yeah.
was also a problem for the father.
Yeah,
So
based on
I,
the information we have, got it from our sources, turns out she was just an employee of the academy and did not have a very big social media presence. But like you said, there is so much more that we need to know in this case.
yes,
Yeah,
correct.
and
It is
even if
only after
hmm,
it is only after unearthing each and everything, putting the piece together with the whole story, There might be an
Mm.
involvement of a boy. There might be an involvement, or maybe, she was just, you know, ahead of the people around her. Sometimes you just outgrow the families you are born into. She might be of a different mindset and, might be challenging the father, and the father having a fragile ego, maybe did not know that. So we do not know how
Mm.
or what were the intricacies and how the family actually managed to be.
Right, right. So even like you mentioned, like the lawyer would like to really use the tool of insanity plea, or if even if it was already planned, would there be any condition where the father can seek a possibility? Can there be a possibility of a bail? Is it even likely
Possibility of what?
of a bail?
Bail.
Yeah.
See, their criminal matters generally, in terms of, you've seen the kind of cases that recently have come to light. It has to
Right.
classify as to rarest of the rare case to be, to be sentenced for life imprisonment or death. And
Mm-hmm.
he will have to argue it out really, well. And like I said, just taking a plea is not enough. You will have
Right.
to provide proof to that. You will have to provide some evidence. You will have to go through the entire procedure of trial. And
Mm-hmm.
like I said, there have to be more corroboratory statements. The statement of the brother and the
Right.
mother, they are very relevant. And also,
Mm-hmm.
as to how the family dynamics were, what was the relationship between the father and the daughter, a lot will be
Right.
taken into account, and only then will we
Mm.
be able to, reach any conclusion.
Say
But
more.
like I said, like,
Mm.
it is a very strong doctrine, the rarest of the rare case, that, and Supreme Court has been very stringent. It is not
Right.
that, you can apply it anywhere and elsewhere. The
Mm.
recent even if you see the Sheena Bora murder case,
Yeah, yeah.
the woman also, she, it was after a very thorough, long time taking
Oh, very
investigation.
nice.
We got
Definitely,
to know
yes.
what actually happened, and she
Yeah,
was
yeah.
sentenced. So yes,
Mm.
things do happen, but again, if he's able to, if, the plea of insanity is being taken, then it cannot
Mm.
be just a plea. You'll have to justify it. You'll have to prove it in court. That is more
Mm.
important, and for that he'll be needing a lot more than just, taking that plea.
Mm-hmm. There's been said that there's a lot of parental pressure or anger. It could be an act of rage, but do we really see them as mitigating factors? I mean, how has this been in any of the previous cases, and how has the court interpreted those?
See, firstly, you're saying, it's a sudden act of provocation, if we take it
Right.
that way.
Yeah.
How can you forget that you're a parent? And I would say something is terribly wrong with you if, you walk by certain people in your own village or in your own area, and, some statements are being said about your daughter. Does that really provoke you to the level that you shoot 3 times your own daughter? It
Right. Right.
has to be, you have to be somewhat twisted enough to do that. And
Mm.
again, there is no proper, if you construct their whole story, there is no proper or convincing factor that could actually provoke him. It
Right.
doesn't add up. It has to, there has to be something either more, maybe, like I said, we do not have the complete information. But yeah,
Right.
in terms of, you say how the courts interpret it, again, they will not take it. Courts go by what the law says, and the law is very clear. If you are taking plea, you have to establish that, you lacked that necessary mental capacity, and you were of unsound mind, and you could not distinguish right from
Mm.
wrong, and that is why you were able to, pull the trigger.
Right.
So the court follows the complete yardstick that has been laid down. The law is very clear in all this. So there is no haywire theory, or it's not something available for discretion. You
Right.
stand before
Right.
the court. If the law is biased, the law
Mm.
supports you, definitely the court will let you go. But if the
Mm.
law does not support you, then there's no point. You can spin stories as much as you want. Because obviously,
Mm-hmm.
when you're an accused, you
Right.
would want to latch on to any available defense. And in these kind of cases, the best available defense is always, that I was not in the, right
Right.
mind. It was a fit of rage and
Hmm.
this and that happened. So these things do happen. Let me remind you, a very famous case, since you mentioned the word rage, the famous Nanavati case.
Mm-hmm. Yeah, yeah.
So
Yep.
the husband shot
It.
the
Yeah.
wife's lover,
Right.
and
Hmm.
so that is understood that all right, that was complete fit of rage, and he was able to again.
Yeah.
He did not get any sentence, and he was able to make his case. So
Mm-hmm.
there are always exceptions, and the courts over the years have also evolved. So
Right.
to again
Mm.
justify where you're coming from, you have to explain, and you have to take law as the only crutch available. Only then you'll be able to establish your case. So it's
Right.
relevant, even though courts
Mm.
have a very different, you know, over the years, things have changed. We have
Mm.
evolved. Times have changed. We have technology also into play.
Right.
And the cases that we've just discussed and I've referred, you can see each case has been dealt very differently. So there is
Yeah.
no straitjacket formula. You have
Mm-hmm.
to see through various facts available, and there's an entire trial procedure. Only
Right.
after all the witnesses have been cross-examined, the evidence has been taken into a court, then only will the court reach to a conclusion and give its
Mm.
decision, pass a
Right.
judgment on it.
Okay. Thank you so much, Isha, for joining us. We at the federal
Most
will
welcome.
keep discussing the case as more updates come in. Thank you so much for joining us.
Most welcome.